Irwin. We are coming to you live from the law office of Alan Butel here in downtown Las Vegas. Alan Butel, if you're not familiar with his practice, handles criminal defense and civil litigation and is frequently a guest on our show, Fired Up with Bob Irwin. This show is about guns, related politics, and self-defense issues. Fired Up is on radio at KSHP 1400 AM on radio and on YouTube. If you go to YouTube and find Fired Up with Bob Irwin. We had a change now in our radio rebroadcast. The regular listeners will know that we've been getting preempted on a rather regular basis because KSHP 1400 AM carries Dodger games now by contract. So we have moved our radio rebroadcast time from Saturday night at 9 p.m. to Sunday morning at 9 a.m. starting this week. So on your way to church, when you first get up in the morning, you can listen to Fired Up on 1400 AM radio. It's a rebroadcast of this YouTube show. If you're watching the YouTube show, you already heard it. But we'll be on Sunday morning from 9 to 10 a.m. for their radio rebroadcast. The YouTube version, of course, is our mainstay, and that is online 24/7. Once this show goes up, it will go up simultaneously with this broadcast. We will be on forever. You can look up shows going back 4 or 5 years now if you want to see what I said 3 years ago that turned out to be wrong. That happens in real life. Today's guest is Nevada and California attorney Donald Green. Don, a bit of your background for anybody who hasn't heard of you that owns a gun in Nevada, which would be hard to imagine.
Thanks, Bob. Again, my name is Don Green. I'm a lawyer here in Nevada, and I'm also licensed in California the past near 34 years. Again, the substantial emphasis of my practice is criminal defense, gun-related issues, and serious business litigation. As to gun litigation or gun cases, not only criminal cases, but administrative proceedings before the FBI, Bureau of Alcohol, Tobacco, Firearms, and Explosives, local administrative proceedings concerning concealed weapons permits, firearms applications, challenges to denials of firearms records, or where there's a question as to whether or not you can get a firearm. You can come to my office, and you can either send an email to firedup.com and their email there, and they'll get it to me, or you could visit my website at dongreenlaw.com, or you can call me on my direct cellular at area code 702-409-8239. Thank you, Bob.
Yeah, if you go to any of the gun shows around Southern Nevada, you have seen Don. The guy, we're going to have a segment later on in the show, not about another 20 minutes, on some gun laws in California and Nevada that Don is working on opposition to, that we need to, I'm giving him a little bit of airtime because it's an important, actually very important thing for Nevada gun owners. First off, though, we're going to talk about, as we normally do, a couple of shootings that took place, self-defense cases with guns. As most of you know, the mainstream media doesn't cover very much good use of firearms. They cover bad use of firearms. So we try to counter that in our small way by presenting 1 or 2 or 3 or 4 of the good uses of firearms for self-defense that take place in the United States every week. Where we use a Nevada or California case, we've got, in this case, we have Don here to explain the law and how it works. If you were involved in an actual case, because this show goes worldwide, we suggest that you get local counsel because the nuances of the law are different from one jurisdiction to the other. It goes without saying what may be a good shooting in Wyoming is not going to be a good shooting in New York City. So if you're involved in a case, we're not offering you legal advice because you need local counsel for the nuances of the law there. So some of the cases we use are good shooting. Some are bad shootings. Once in a while, one that's really stupid. But the idea here is that the listeners can put themselves in the position of the parties involved and see what they could have done or should have done. And I will comment as a firearms trainer on what I think, and Don will comment on what he sees as an attorney to give you an idea of what could or should have been done. This first story is from KTLA TV5 in Los Angeles. Most of you in the LA area are familiar with Channel 5. And this is a bad shooting, sort of. We'll explain what happened. A motorist accidentally shot himself in the leg after getting into a road rage confrontation with another man in Victorville on the 29th of April. This was reported on the 29th of April. The man accidentally shot himself in the leg during a road rage altercation with another man. Deputies responded to a shopping center parking lot around 4:30 in the afternoon Saturday after receiving reports a man had been assaulted and possibly shot. Deputies found the male victim, he's 54 years old, at the scene suffering from a gunshot wound to his leg. He apparently shot himself during the incident. Also involved a 21-year-old aggressor that had started on Petaluma Road and Mall Boulevard, if you know where that is in Victorville. The victim was the driver of his car, and the aggressor was a passenger in a car driven by his girlfriend. The sheriff's investigators say the 54-year-old guy pulled into a parking lot on Bear Valley Road, and the 21-year-old followed him into the parking lot. They apparently had a disagreement over who almost sideswiped who. It was a road rage thing. The 21-year-old got out of his car and confronted the 54-year-old about his driving. He then began repeatedly punching the victim in the face. He's sitting in his car getting punched through the open window. The 54-year-old victim has a valid concealed carry permit. He pulled his handgun from his waistband because he feared for his own safety and his wife's safety. His carry gun accidentally discharged while he was retrieving it, resulting in him shooting himself in the leg. The young attacker and his girlfriend fled the scene. I guess warning shots actually work, even if you shoot yourself. Anyway, the bad guy fled. He was apprehended just up the road. The girlfriend, he fled on foot. The girlfriend returned to the scene on her own. She was driving her car. He was cited, and the guy was cited and released at the scene. The wounded shooter was transported to a local hospital. He has fortunately non-life-threatening gunshot wound, as well as injuries suffered and hits in the face because of the original assault. Yeah, I make a joke here. Firing a warning shot is something we talk about often on the show. A warning shot where you shoot yourself in the leg, I guess you know where the bullet's going. That's okay. I don't want to be flippant. This is obviously a bad example. Once again, we have the issue. Had this guy not been armed and pulls into a shopping center with this guy following him in, getting out of his car, walking over and starting to beat him in the face through his open window, what happens to him and his wife if the guy is not armed? Carry your gun. Comments, Don?
That's correct. Bob, in the hundreds of examples that you and I have discussed over the course of time, this is probably one of the most, one of the examples which directly affects all of your viewers and all of your listeners every single day. We hear about a road rage incident, and there's probably not a day that doesn't go by that somebody's not honking their horn at you, that they don't cut you off,
Yep.
that they want that parking space at Walmart. And this illustrates that you don't have to be confronted with deadly force in order to present your concealed carry firearm. In this case, the standard in California and the standard in Nevada is great bodily harm or deadly force. Being pummeled in the face by a 21-year-old person and you're 54 years old is great bodily harm under any standard. And when a person is presented with this scenario and he is validly carrying, he can defend himself with an equal or greater force to stop the threat. Now, could he have used that firearm to kill? Well, the 54-year-old man, who's younger than both of us, may not have known that, but that's not the standard. That may be some subjective standard which is used by the district attorney there in San Bernardino County where Victorville sits. But the point is that he did present this. Now, it's kind of an issue of training and maybe proper holstering. As you point out in your notes about training in the police academy, you spent probably an inordinate amount of time learning to draw your weapon from a seated position.
A separate problem which comes up here, obviously.
Yes, sir. But I think that the thing is that we see this every day, and I would highly recommend to your viewers from a legal standpoint, I'm not talking about a training standpoint, from a legal standpoint, that they strongly consider or reconsider how they're placing their weapon on their person in a concealed format inside their vehicle, because this can and this will happen somewhere at some time.
Absolutely. As Don alluded to, when I was teaching police academies, this is something we run into all the time, because uniform officers commonly and police officers carry their gun on their belt, usually strong side, sometimes weak side, depending on what they're doing. And what we discovered in drills is the officers will be attacked before they get a chance to get out of their car. Police cars take gunfire, things happen. How do you get your gun out? And when we ran the kids with the practice of it with an empty gun and said, okay, here we are. Now you're taking fire from the left side of the car. So you're going to have to bail out the right side of the car and get over the radio and everything. But how do you get your gun out? And they would try to draw their gun and discover when you're hooked in a seatbelt, especially one with a cross strap, which they all have, you cannot draw your gun from your belt area. You have to unhook the seatbelt first. If you don't, you're going to get all tangled up in the seatbelt and get yourself shot. So the point of the study and why I picked up this particular story was that problem. If you are in the car, you need to get in the habit of the guy walks up to the window in this case and starts punching him. First solution might be to step on the gas and drive away, hopefully with his arm still in the window. But obviously that wasn't available at this point, because our first thing normally would be withdraw if you can. He was obviously in a position where he couldn't drive away. So you have to get in the habit of unhooking the seatbelt as you go to draw the gun and unhooking the seatbelt first. You have to. So practice that with an empty gun, sitting in your car, wherever you normally carry your gun. Try it. Have an empty gun, because you don't want to be this guy and shoot yourself in the leg while you're practicing this. You will discover unhook your seatbelt first is the rule.
Or buy one of those blue plastic firearms, those training guns,
Yes.
which are similar or identical to what you carry.
Yeah. But try it. You'll be amazed at how well you cannot get your gun out. I tell a story on myself, and I know I've said it on the air at one point. Years ago when I was young and stupid, I was working as a bodyguard for somebody, and I got a new suit vest that had level 2 body armor in it at the time. It was a vest that was plaid and looked really cute, but it didn't actually unbutton. You put it on with straps on the side. And I put that on, and I was carrying a gun in a shoulder holster at the time, and discovered when I was out doing my bodyguard thing that when I was sitting in a restaurant booth, because the person I was guarding was in a coffee shop, I discovered once I was there that the vest curled up and I could not reach my shoulder holster with my arm because it locked up on the thickness of the vest. Vests were quite a bit heavier then. I hadn't practiced it. Well, obviously you should. That's a story on me. When you try to draw your gun from your belt holster when you're strapped into a car, And I tried to draw my gun with a vest I'd never tried before when I was sitting down, and discovered I couldn't reach the gun. So with your equipment, try it. Make sure it works. The St. Louis Post-Dispatch and the New York Post both reported on the 24th of this month, or last month, in St. Louis, Missouri, a 7-Eleven convenience store clerk was hailed as a hero by fellow employees after police said she fatally shot a would-be robber during her smoke break. The wild confrontation unfolded after this 35-year-old worker, who was not identified, stepped outside for a smoke break during her shift at a 7-Eleven in St. Louis just before 4 a.m. This store is located at 509 Bates Street, if you are familiar with St. Louis. An armed man approached her and tried to rob her, but she pulled out a pistol and shot the guy instead. She hit him in the chest, arm, and thigh, fired several rounds. The suspect, age 30, later died at a St. Louis hospital. The female clerk, who was shot twice in the leg during the gunfight, was listed in stable condition. Employees at the convenience store said she had worked at the store for years and years. A man who lived near the store said he didn't know the female clerk very well, but she was a mother who had worked hard and was respected by customers. And this man who lived nearby said the gunman deserved what he got for pointing a weapon at her. Employees told the newspaper that another employee who was working with the woman at the time of the robbery quit that day. He said the store had been robbed before, but this is the first time he knew of anyone getting hurt. We need a security guard, said the employee, adding that the risk of working at night isn't worth the money. That may be true of several convenience stores. He says he thinks anybody would defend themselves if they were in her position. It's sad, man, he said. The robbery attempt at the 7-Eleven. This area has been getting rough lately. I hear too many sirens and gunshots at night. Now, the female clerk was legally carrying her pistol, apparently. They may have 7-Eleven has a rule, as we all know, about the employees not being armed, but she was on her break outside at the time. I'm not sure that applies. So anyway, when a street thug decides she's going to be the next victim, the choice is always your choice. Her choice was to fight. We can presume she saved others because this guy was probably going to rob the store. This was currently obviously not his first rodeo. She intercepted him being in the parking lot on her break. He wound it to her, maybe, instead of going into the store. We won't know because dead men tell no tales. Obviously, if you're confronted with a guy with a gun and you're carrying a gun, you have a decision to make right there. If you turn and run, high probability you're going to get shot in the back. He may just shoot you in the front anyway. This is a decision that only the person involved can make. And I don't have the view of the parking lot, where the parked cars were to hide behind, where everything was, how far away the guy actually was, and so forth. We don't have all those details. So when she faced this choice of either running or complying or fighting, she chose to fight. I can't second guess her. I've learned over many, many cases over many, many years, don't second guess the person that's actually got the gun pointed at them. It is their decision only. Interestingly enough, she works at a 7-Eleven, where we know we have some policy issues there. Maybe this store doesn't. I'll leave that one to you.
Okay.
Legally, could she lose her job?
Theoretically, she might lose her job, but I think that she perhaps may even save some of the other employees in the 7-Eleven, may save at least the money or whatever they may have was going to be the object of the robbery. But this exercise shows that the shootings which a concealed carry permit holder may be involved in are not always in the home. According to the statistics, there's a 25% chance of a shooting in a home. There's a 25% chance of shooting in a store, 25% chance of shooting at work, and 25% chance of shooting in a car. That's all. It's 100%. This is just about what it is. Maybe these statistics are a little bit off, but according to, if we look at the legal analysis, there was a clear threat of great bodily harm. Absolutely. He had a firearm or death. The clerk obviously had some type of training, assessed the situation in milliseconds. Notice that according to the reports, the perpetrator approached her. She looked at it, again, correctly assessed the situation. She shot to address the immediate threat. She shot him in the, I believe it was in the chest, in the arm, and the thigh. And she received, as I recall, a couple of gunshot wounds herself.
Yes.
All right. So she shot to stop the threat, which is in Nevada. You don't shoot to kill. If a person is killed incidentally in the act of shooting to address the threat, that may become justified. But she shot to address the threat. She's alive probably because of prior training, the common sense, and at that moment, a very cool head.
Yeah. Tough decision. And that's one of the things we will harp on is when you're carrying a gun, you need to be aware of your surroundings. She obviously was. And pre-assess, you know, you look at, when you're in a store, you look at what are the escape routes? What would I do right now if somebody came in the door firing in a robbery of the store? Could I duck? What would I hide behind? Where would the exit be? If you can, you become, you know, it's not to become paranoid, but you need to be generally aware of your surroundings, not with your face stuck in your cell phone or something so you can't even tell when bad guys walk in the door. If you see something suspicious happening, you can remove yourself from the store, call the police from outside, see what happens. This lady, hopefully, she has 2 kids at home, I understand, or 3, will not be the victim of the 7-Eleven policy. I don't know what they're going to do with this. She was on her break at the time and outside the store. So we don't know. ABC TV, Channel 15, this is in Mesa, Arizona. On the 24th of last month, a Mesa woman fired a shot from a rifle to scare off an intruder attempting to enter through a window of her home. Mesa police report that a week earlier on April 17, a 31-year-old man was halfway through the front door of the home, which is near Main Street and Higley Road, when he was shoved back out by the victim. He then allegedly attempted to enter the home through a window. He removed the screen, and that was seen by the victim's child, who was in the home at the time. The child ignited, obviously. The woman ran into the room with a rifle and pointed at the man, warning him multiple times to leave. What else can you do? He continued trying to break through the window. The woman fired 1 shot, striking the window near him. That caused him to leave, but he returned later, pounding on the door and the same window again. This time the police were there to detain him. They had responded to a 911 call and were in the area when he came back. Police say the would-be intruder is known to the victim's family. It had been an ongoing dispute. He was also known to carry a pellet gun. The victim reported to police she was in fear of the safety of herself and her small children. The suspect told police he was continuing an altercation between him and another person who was hiding in the home. He was then arrested for burglary and disorderly conduct. Obviously, there's some other dispute going on here, and apparently the other person wasn't hiding in the home. He just thought they would be. This is kind of the criminal mentality you have to understand with your opponents. How stupid does a bad guy have to be when he's trying to break into a home, a shot is fired at him that shatters the window next to him, he leaves and comes back trying to go through the same window or a different window in the house again? He's already been shot at. I never assume that the guy trying to break into your home or the criminal on the street has an ounce of common sense, I can't imagine which of us trying to break into a house when the round goes through the window next to you would come back. There's got to be other houses to rob. Yeah, anyway, apparently whatever dispute was going on, the courts will cover that when they look into this. There may be reasons why the person who was allegedly hiding in the house didn't use the court system to get a restraining order or something, but it doesn't really matter. So he's hiding in the house. We all know that the court orders anyway don't stop people. We have court orders violated all the time. It is a piece of paper. Sometimes it scares people off, bad guys. It will, if you get a court order for protection or you get him away from your house, will give you an extra leg up if litigation happens over the shooting. You shoot somebody and so on. And you had that previous record, your attorney will be overjoyed that you had done that. But the point of this one is just to look at how criminals don't think like you. They think like criminals. Never assume they're going to do something rational.
That is correct. That's correct, Bob. And you note in here in your when you extracted this, that the victim reported to the police that she was fearing for the safety of herself and her small children. That is an almost immediate response, which should come out of the mouths of all of your viewers and all of your listeners at the outset of any shooting, while reporting it immediately to the police at 911. My name is whatever. I'm a concealed carry holder. I'm a legal carrier of a firearm. I'm in the parking lot at this particular intersection. Describe yourself. There's a man who has been shot. I shot him. I was in fear for my life and my mother and my children who are in the vehicle. There's a weapon displayed. I want to speak to my lawyer. But those words, fear for the safety of yourself and small children. But there's, as you said, the courts are going to have to work this one through, because there's 3 specific threats. Halfway through the window, doorway, and then he comes back and is arrested by the police during an obvious attempted burglary. So there's something there. And then you mentioned about, if you get a restraining order or some kind of a protective order, that's good if the protective order is legal, it's legitimate, and it's well-founded.
Yeah. I've run into a lot of people who don't want to use the court system. They don't want to get involved. But if you've got an ongoing situation, tell your best friend that in confidence that, this guy has been harassing me and he did this on this day or that day. So you have some witness at least that can say this was an ongoing problem. So if the worst thing happens, there's somebody there to say this wasn't a spur of the moment thing. She was harassed. Mm-hmm. Why she didn't go to the police, we don't know. Some people don't. For any number of reasons. I've actually talked to a woman who didn't get a restraining order because she had a criminal history and thought the police wouldn't believe her. Well, women with criminal history get attacked by criminals. It happens. They're going to judge that on its own merits. If you're not doing something criminal at the time, it's okay. They'll defend you. The Nevada legislature and the California legislature are working at the moment on some gun restrictions. We've got, for those of us in Nevada and California, we have Democratic majorities in the legislature. In California, they've got a Democratic governor on top of that. There's some stuff going on in our legislature in California that needs to be addressed, and Don asked, he's involved in stopping the litigation. So I gave him a little bit of the show to talk about that. So here we are. Pay attention. The bad guys are coming to get your guns.
Thank you, Bob. First of all, what we're saying today on your show is it may be construed as political commentary, but it's meant to address all of your legal Nevada CCW holders and all of your viewers in the state of Nevada and all of your listeners who own firearms, because this law, Senate Bill 387, which was passed last week, and the new Assembly bill, which is yet to be designated, affects all of us. The Senate Bill 387 is labeled Orders for Protection. Now, that sounds good.
Sounds good.
No one likes domestic violence. Everyone agrees that there are instances for the issuance of protective orders. But when you read this law, you notice that it is not a law for an order for protection. It is an order for the seizure of firearms upon an application by a specifically defined family member or law enforcement which has received information from a specifically defined family member that the person, the gun owner, is a threat to himself or others, has made that threat, or the threat has been made in the past 6 months, or has been made in the past 365 days with a pattern of conduct concerning a threat to himself or others, his guns can be seized. All of the guns. Now, my questions is, yes, there are some legal arguments. If there was something happened 6 months ago, why is that an imminent threat? Well, that goes to a legal argument against that. But for your audience, they may not have heard about this bill because there's almost been no media coverage. There's been very little, but almost no mainstream media coverage of this bill. Is it a media blackout? The proponents do want an ignorant public, because if legitimate gun owners can say, listen, I'm in the middle of a divorce, so are you telling me that if my soon-to-be ex-wife calls the police in order to gain a tactical advantage in the divorce and says that I threatened to harm myself, then my guns can be confiscated? This is without a court hearing. The gun confiscation bill was again passed last week by the Nevada Senate by a vote of 12-9, almost along party lines, Democrats and Republicans, although there was, I believe, one Republican who did vote for the bill. It has now been passed over to the Nevada Assembly this week with, again, little fanfare, virtually no mainstream media coverage, and probably a near media blackout of this law pending in the Nevada Assembly. Why defeat this gun seizure legislation? A, there will be abuses by family members or a soon-to-be ex-spouse.
Sure.
We know that's going to happen. It's not a matter of if, it's when. The abuses will mean that there will be misinformed law enforcement officers, good men and women of law enforcement, who have been presented with erroneous or false information, and they will base the confiscation and seizure of firearms on erroneous information, which can only be challenged in one hearing, which is calendared after the seizure if the person wants to have a hearing, not before. The statutorily defined claimants will be able to literally make up any story of the gun owner's imminent threat to himself or herself and others. They may make the claim going back 6 months, so where's the imminent threat? Or they may claim back to 1 year, making the accusation of the threat if a pattern of conduct is established through their hearsay testimony to a clerk of the municipal court or the justice court, not in a court hearing. So where's the imminent threat? Now, Bob, I've been practicing law almost 34 years. I've known you almost all those 34 years. And in my experience, the municipal court judges and the justices of the peace who are going to be given the jurisdiction, that is the power to issue these orders, number one, they will issue the orders for the seizure of the person's firearms. Of course. There's not a judge in Nevada who's going to deny it unless the judge perhaps some personal knowledge of the parties and maybe he or she, the judge, should excuse themselves from the case. But they're going to say, wait a minute, I got to stop this. And the seizure is all firearms, not just the firearms that are in your closet. All the firearms you have it over at your brother's house, which you have at your mother, that are being repaired at with the gunsmith. And the municipal court judges and the justice of the peace, all fine people following the law, can issue the orders for the seizure of the firearms ex parte. That means without an initial hearing, based only on the hearsay statements of a family member or perhaps a soon-to-be ex-spouse. The judges can order a hearing on the initial application. Again, they can do it secretly, and then you get served with the order. That may be the first time that you hear, excuse me about the hands, that may be the first time that you hear about this. The judge can order the presence of the accused at the initial hearing.
Can order it, not required. If the order is issued, here are the direct and collateral effects. If you contact my office, we're going to try to post this on the website, but we'd also email it to you, kind of like this outline. But if the order is issued, all firearms will be seized. All firearms will go to a federal firearms licensee, or all firearms will go to the police. Your rights as to those firearms will be stripped before a hearing. The seizure of the firearms shall be reported to the Nevada Central Repository for Criminal Records. In turn, in my experience of 3 decades dealing with firearms, there's a 99% probability that this seizure will be picked up by the FBI and their National Crime Instant, that National Instant Credit, not credit, Crime Information Center check, the NICS system, excuse me, and it will be lodged as either a temporary protective order or some form of generic prohibition under mental incompetency. I'm a danger to myself, which would preclude the recovery, purchase, or acquisition of firearms, because you'd have to fill out the form 4473 of the ATF, which asks you
that question. Once you check the word yes, it's automatic. If you check no, you could be arrested for a false statement. That's a federal felony.
You made a great point, which is not obvious to everybody in the court system, how the court system works. But you said the judge will issue it. Of course they will. If the woman or the complainant comes in and says to the clerk, I'm afraid that my husband is going to hurt himself or hurt me, here's the complaint. How can he not issue the order? The downside risk to him is tremendous. So he's going to say, I won't issue this order. One, he'll be unelected next time he's in office, because even if the order, signing the order is not signing the order is the right thing to do. Judges are political animals. They're elected here. But if he can't afford to be wrong, he says, if I issue this, worst case, this guy loses his guns for a couple of weeks, and I'll have him here for a hearing. that hurts him. If I'm wrong in not issuing it and the woman gets killed or the guy kills himself or whatever, I'm responsible for that. He will issue the order. And there's no way around it. I've been in these hearings, and we have, because you don't work divorce law, we have the same thing happening in divorce court constantly here. I've been involved in a couple of cases where the one half wants a divorce, and as they say, just as a harassment thing, the attorney, the lady's divorce attorney or the husband's divorce attorney, usually this is the lady's attorney, says, you know, have him, you know, you're a little afraid that he has guns, so let's throw in the order that he can't, you know, keep his guns for 5 years or whatever, and he will sign that order because he wants his divorce, or he doesn't have an attorney, he doesn't read it, and he loses his guns because he voluntarily gave them up. And it's a negotiating thing in the divorce. I'll let you, you know, you don't let me keep, I'm going to take all your guns, or you have to turn them in and you get the car or whatever. You know, the guy will negotiate his gun rights away. But divorce lawyers use that as a wedge in the divorce to get something from the other side. And the guy doesn't realize that he's going to lose his guns for at least 5 years and end up in the NICS system as a prohibited party and so forth and so on. These things snowball with all these computers we have now. This is a really dangerous law where someone can, actually, if I'm reading correctly, a third party can do this under certain circumstances. Say, I'm a neighbor and this is what I think's going on.
It can't be the neighbor, but the neighbor could say something to the brother. It has to be within the second degree of consanguinity. Grandfather, uncle, grandfather, brother, sister, daughter, mother. It's got to be within that. But the word just has to get out to some designated family member.
And do they have to live in the same state?
No. Well, no, it doesn't say that. It just says that the family member has to make the application. And the statute does say, and you make, let me get to this point before I forget about what you just stated. We are presently litigating a case right now in which the restraining order was buried in a 1992 divorce decree in New Jersey. And the client found out about that in December 2016, some 24 years later. So
that he wasn't allowed to have guns.
Exactly. And it's buried inside. So there's someone scanning this information. Someone's putting this information, but now it's going to be directly, according to the statute in Nevada, the clerk, here's what happens. The complainant goes to the clerk's office. The law says the clerk shall assist the complainant in filling out the paperwork. The clerk presents it to the court. The court makes the decision. The next paragraph says that the clerk's assistance to the complainant shall not be construed as the practice of law. And if you go to any courthouse in the state of Nevada, I don't care whether you're in Bunkerville, whether you're in Wendover, whether you're in Washoe County, whether you're in Las Vegas, there's a sign in front of every clerk's window in every courthouse of this state that says that the clerk cannot give legal advice. I don't know what it is, but it's I know it when I see it, and this is legal advice, and they are specifically excusing the clerks of this state. Now, they're doing their job as well, but it's a built-in system for the issuance of the order, and you only get one shot. And although they've amended the standard of proof and how they've got to prove it, it's still an exceedingly high standard, which you, as the person whose weapons have been taken away, you have to show a very high standard that I am no longer a danger to myself or others. If you lose that, you will surely end up with an entry in your FBI record, which could perhaps prohibit you from owning a firearm the rest of your life. Okay. If I may take 30 seconds, What can responsible gun owners in Nevada do? Call Governor Sandoval. His main number is area code 775 684 5670. In Las Vegas, the governor's telephone number is area code 702 486 2500. Call your assembly person. In Carson City, the main number is area code 775 978 2878. In Las Vegas, the main number for the Nevada Assembly is area code 702 486 2626. Or there's an excellent resource. It's called the Firearms Policy Committee, which has been doing some grassroots work tracking this law. And we've been following their particular emails and their blogs and their analysis. You can find them at Actions, that's ACTIONS, at firearmspolicy.org. That's Actions at firearmspolicy.org, or go online to Firearms Policy Committee. They have some excellent analysis of this law. They break it down for you. And again, I call it the Papers, Please statute, where it reminds me of something which happened, in World War II in Germany, when they would just come into your house and ask for your papers. Now they're asking for your guns. What is this all about? Well, we're just taking your guns.
That's another problem that comes up that you haven't touched on with this. If the person, they go through all the court thing and they get a court order that the guy has to turn his guns in because he's a threat to himself or others. And that's what the court order says. When the police are told to respond to this house because he didn't come down and turn his guns into the court, where are you supposed to turn them in? To the court or to an FFL?
An FFL,
okay,
a federal firearms licensee, or the police.
He didn't do that. He ignores it. So how are the police going to react? They're told to go to this house where there is a guy who's been ordered by the court because he's mentally unstable. They're going to send 2 bicycle officers?
No.
They're going to send a SWAT team
with a search warrant, which is specifically stated in the statute.
And because they know the guy, it says in the bill, the court order, the guy's crazy and he's a danger to himself and others, and he's got guns. Of course, they're going to send a SWAT team. So we're liable. This just will spiral out of control because of law enforcement policies. They're not going to send a patrol unit by and go, "Hi, can I have all your guns while I'm here?" And he said, "I didn't get any court order. Nobody told me nothing. My mail doesn't come. They send, da 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 da. I didn't get it." Well, surprise, we're here to take all your guns. This is a disaster waiting to happen. And Don, I see the governor's going to be in the same position if this hits his desk. Is he going to put all of these people in danger for all these wackos by vetoing this bill? He's going to be in the same position politically. And we'll find out. Now, he's a federal judge. He knows everything that's wrong with this. He's well-versed on the law. We disagree on a few things here and there, the governor and I, but you can't argue with his legal intelligence and his experience. What is he going to do when the 5,000 letters show up from the anti-gun people that say, don't let these wackos have their guns? This is a bill designed to take guns away from mentally ill people who are a danger to themselves and others.
And not necessarily mentally ill. People who a family member says it's a threat to themselves, just like in California. And remember, it was only almost 18 months after the law became effective in California in 2015 that it wasn't until November 2016 that the California legislature enacted a bill of what to do if there's a false statement. And they said, oh, we forgot about it. We'll just make it a misdemeanor after someone's life has been thrown into turmoil. Remember, this is defined as and under orders for protection, which everybody agrees with, not as a gun confiscation bill. If it was labeled as a gun confiscation bill, there would be a storming of the Bastille in Carson City.
The politicians that are trying to put this through are very good at it. It has really, in my opinion, has very little to do with making anybody safe. It has to do with a way to get guns away from people.
Yes.
And there we are. Let me, we're coming up on 50 minutes. I want to first do the little closing bit, and then I'm going to try and run one more story if I can after. Gun shows upcoming. We've got the Western Trails Gun and Knife Show this weekend, May 6 and 7 at the Henderson Convention Center. They have free parking. They advertise, and it's only $12 to get in. I may be down there on Saturday if I get loose to talk to anybody who would like in person. At the Las Vegas Gun Show, May 13 and 14 at the Sports Center, we will be there with a table. That's 2 weeks or next weekend after. And the big one, the Crossroads of the West Gun Show, June 10 and 11 at Cashman. We will be there also. For the Cashman Show, I do have a number of these passes left. If you want to drop a call, send a note to my website, firedupwithbob.com or firedupmail.com, or the phone number that's listed there, and leave me your contact information. I will mail you a pass. One, please. The reason the show gives them away to get more people there. If you ask me for 4 passes so all your buds can go too, that's not what they're done for. But it'll help you bring your wife in to the gun show so you can get her in. Next week, oh yeah, in the gun show this weekend, oh, if you mention Don Green's name, you get $1 off.
$1 is $1 when there's no free parking. When there's free parking.
Anyway, reminder: the radio show will duplicate this on Sunday at 9 to 10 a.m. Please let your email friends know that we're going to be on Sunday 9 a.m. to 10 a.m. on 1400 a.m. KSHP. No way to tell anybody that unless they're already a listener to find the show. We will be on YouTube from 5 to 6 as normal on Thursday. Next week, I have murder defense specialist Clark Patrick on once again, who does nothing but capital cases or cases where life imprisonment is possible, and a wealth of knowledge, a gun guy and knowledgeable on this stuff. We've got a couple of things to look at when he is on next week that are stories I'm not going to get to. Please remind everybody that we are on Sundays at 9 a.m. KSHP and on Fired Up whenever you want to look at it. Questions and comments to bob@firedupmail.com. If you don't remember Don's contact information, drop me a note, bob@firedupmail.com, and I will forward all that stuff to you or any of our other attorneys and so forth that work on these cases with us. So now we should be at 7 minutes left. So we're going to do story number 5 here because I like this. This is a good story. It's a story that tells me there is hope for us all. Action News in Jacksonville, Florida, which is a co-op at CBS Channel 47 and Fox Channel 30, reported on the 3rd of this month, a couple days ago, a local woman shot an attempted robber at her Myrtle Street home just before 10 in the morning. The victim said the home invader followed her home from a nearby store and forced his way into the woman's house. That's fairly common, unfortunately. If you're not paying attention, when you are taking the groceries out of the car, you want to walk all the way to the kitchen and he follows you right through the door. Or while you're fumbling with the keys, he shoves you through the door. Anyway, he pushed his way into the house. He demanded money. Instead of donating, this lady grabbed a handgun and shot the guy. Hooray. Police investigators learned the man was shot after he had walked a few blocks away and called 911. The officers responding to that McConaughey Street call found a man with a bullet wound in his torso. A few minutes later, officers were called to the Myrtle Street address on reports of a robbery. The woman there said she had just shot a man who forcibly into her home during the attempted robbery. They already had the guy in custody because he called the police and said somebody shot him. He was taken to University of Florida Health in Jacksonville for injuries not considered life-threatening. This is a common problem. He followed her home, pushed through the door. She failed to lock the door behind her, went to the kitchen first, or whatever, or he entered anyway. Every day in the country, there are hundreds of these kind of robberies. The difficulty here is if she complies with his demands for money, and he's there long enough to realize that she's home alone, what happens? She made the choice to grab her gun and fire. Again, this is the second one of these stories we've had on this show. A good choice. Turning your back, leaving your house is just not an option. When the threat is right there, it's the person involved that makes the decision. She made the decision. It was just kind of funny to me that the bad guy called the police first to say he'd been shot, and then they got the call from her. I imagine she's a little disoriented, having just shot somebody in her house. It took her a few seconds to get her act together and call 911, but she did. Always call the police.
That begs the question. I'm presently involved in a case right now where the display of the firearm, where the client did not call the police immediately. So that leaves the victim, or excuse me, the suspect, or would have been a suspect. If he gets to the cops first, he gets to tell his story.
Yep.
This guy probably didn't have much of a chance to tell his story. I mean, after they had investigated the case, but always call the police almost immediately if you can.
You'll get there. Call the cops. Tell them what happened. The guy who calls the police first has a leg up, always. And it shouldn't be that way, but it is. So let them know what's happening. If something's going on that's unusual, call the police. Try not to take action yourself if you can. The police have free lawyers, body armor, and lots of backup. You're responsible, however, for your immediate defense. The police will be there 5 minutes later. Have a gun in your house. Practice. Learn how to use it. It'll serve you well. If you never need it, that's just wonderful.
There you go.
Thank you all for listening to Fired Up. We'll be back in a week with Clark Patrick, attorney at law. Thanks for listening.